धर्मशाला। आई एम मेघा, चैनल होस्ट एंड योर दोस्त। इसलिए मैं प्लान कर रही हूँ लिस्टेड कंपनी रिलेटेड सारे कंप्लायंसेस कॉमशाला पे एक्सप्लेन करने की। सो दिस इज गोइंग टू बी सम सॉर्ट ऑफ सीरीज ऑफ वीडियोस। LODR में जितनी भी कंप्लायंसेस है फॉर लिस्टेड कंपनीज, आज हम लोग इस वीडियो में वो देखेंगे। टुडे इज द फर्स्ट वीडियो। मैं बस टॉपिक्स बताऊंगी आपको एंड सब्सिक्वेंटली आई विल ब्रिंग इलैबोरेटेड वीडियोस ऑन दैट। सो बेसिकली 3-4 तरह के कंप्लायंसेस होते हैं लिस्टेड कंपनीज के लिए। सम आर क्वार्टरली, सम आर हाफ ईयरली, some are yearly, some are event based। तो इन 4 क्राइटेरियाज में कंप्लायंसेस को बांटा गया है। ओके, क्वार्टरली, हाफ ईयरली, ईयरली एंड इवेंट बेस्ड। Then even more are there. Some compliances are applicable to top 100 companies, some are applicable to top 1000 companies, some are applicable to top 2000 companies, and so on. So we'll try to cover all the compliances that LODR contains. Let's begin with the quarterly compliances. The first quarterly compliance is there in Regulation 13(3) of Sebi Lodr. Regulation 13 speaks about grievance redressal mechanism. So Regulation 13(3) is that the listed entity shall file with the recognized stock exchanges on a quarterly basis within 21 days from the end of quarter a statement. Okay, a statement giving the number of investor complaints pending at the beginning of the quarter, those received during the quarter, disposed of during the quarter, and those remaining unresolved at the end of the quarter. So basically Regulation 13(3) is the first quarterly compliance in which a statement has to be provided to the stock exchanges where the securities are listed, in which we have to mention the number of investor complaints that were there in the beginning of the quarter, the number of complaints which we received during the quarter, the number of complaints which we were able to resolve during the quarter, and all the complaints that has been unresolved after the at the end of the quarter which still remains unresolved. That so a statement has to be provided of number of those complaints. This statement has to be submitted within 21 days from the end of the quarter. That means if your March quarter ends on 31st March, then within 21 days after that, that is 21st April is the last date. On or before 21st April, you need to file this statement of investor complaints. Now moving ahead to the next quarterly compliance. Second quarterly compliance is there in Regulation 27. Regulation 27 speaks about the corporate governance requirements. It mentions that the listed entity shall submit a quarterly compliance report on corporate governance in the format as specified by the board from time to time to the recognized stock exchanges within 21 days from the end of each quarter. Okay, so again, if your quarter ends on 31st March, then 21 days, that is 21st April is the last day for your corporate governance report. Now moving ahead to the next quarterly compliance, it comes under Regulation 31, that is shareholding pattern. So Regulation 31 speaks that the listed entity shall submit to the stock exchanges a statement showing holding of securities and shareholding pattern separately for each class of securities in the format specified by the board. And the timeline is on a quarterly basis within 21 days from the end of each quarter. Again, 21 days. Okay. Till now we have seen 3 compliances: Regulation 13, Regulation 27, Regulation 31. And all the 3 has to be filed within 21 days from the end of the quarter. Now next quarterly compliance comes under Regulation 32. That speaks about statement of deviation or variation. Regulation 32 says the listed entity shall submit to the stock exchange the following statement on a quarterly basis for public issue, right issue, preferential issue, etc. indicating category-wise variation between projected utilization of funds made in its offer document or explanatory statement to the notice for the general meeting and the actual utilization of funds. So basically Regulation 32 speaks that when we have issued some funds through public issue, rights issue, preferential issue, etc., in that case we need to place a statement of deviations or variations in front of the audit committee, the board. Whenever the quarterly results are being considered, in that meeting only we need to place this statement of deviation or variation. Only applicable for those companies which have issued, which have raised funds. Okay, up till the funds are fully utilized, till then we need to place a statement of deviation and variation in front of the audit committee and the board. Then we have to file the same with the stock exchange, indicating if there is any deviation from the purpose for which the funds were utilized. So for this timeline is the board meeting or audit committee meeting in which the results will be considered. We need to consider the statement on the same date. And for results, the date is like 45 days from the end of the quarter, and for the last quarter, that is the financial year quarter, 60 days is the timeline provided. So for the other 3 quarters, we have 45 days from the end of the quarter for consideration of results, and for the last quarter, we have 60 days from the end of the financial year. Next compliance also comes under regulation 32 only, that is monitoring agency report. Now same case, whenever we issue funds, if we have hired some monitoring agency to look after the funds utilization, then they'll provide a report. So that report also has to be placed before the audit committee and the board, and same like statement of deviation, it has to be filed with the stock exchange. So next quarterly compliance is the results, which I have already spoken about. The results, the quarterly results have to be considered within 45 days from the end of the quarter. That is, suppose the June quarter ends on 30th June, so 45 days will be, that is full July and 14th of August. So on or before 14th August, we need to hold a audit committee meeting, the board meeting, etc. for consideration of the financial results. This 45 days timeline is for the 3 quarters. The last quarter, that is 4th quarter, which ends on 31st March, the timeline has been provided as 60 days from the end of the quarter. So these were the quarterly compliances covered. Now moving forward to the half-yearly compliances. So the first half-yearly compliances has been provided under Regulation 23 of LODR, which speaks about related party transactions. So a statement on related party transactions has to be provided to the stock exchange on half-yearly basis, and the timeline which has been provided is within 15 days from the publication of the financial results. As and when the results have been considered and declared by the entity, within 15 days from that date, we need to submit a statement on the related party transactions too. Now, as per the recent amendment, this 15 days timeline has been reduced, and now on the same day when the results will be published, we have to provide the related party transactions to the stock exchanges. The next half-yearly compliance is covered under Regulation 33. The listed entity has to submit a statement on assets and liabilities and a statement on cash flow on a half-yearly basis. That means, see, in the first quarter, the listed, and in the first and the third quarter, the listed entity has to submit the quarterly results. Okay, but on a half-year basis, that is second quarter and fourth quarter, the entity has to furnish the statement of assets and liabilities and statement on cash flow also. So this is a half-yearly compliance, and the timeline is, we already know, 45 days from the end of the quarter for the first 3 quarters and 60 days for the last quarter. Now moving towards the yearly compliances. So the first yearly compliances is provided under Regulation 7 of LODR. A listed entity shall submit a compliance certificate certifying the compliance under this regulation. So under Regulation 7.3, we need to submit a compliance certificate that has to be signed by the compliance officer of the company and also the representative of the share transfer agent. So this is a yearly compliance which has to be done within 30 days from the end of the financial year. That means after 31st March, we'll take 30 days time, that is 30th April is the timeline for Regulation 7. Now the second yearly compliance has been provided under Regulation 24A of LODR. So Regulation 24A speaks about every listed entity shall submit a secretarial compliance report in such forms as specified to the exchanges within 60 days from the end of each financial year. If a financial year ends on 31st March, Then after that 60 days time has been provided. That is 30th May is the time for the compliance report. Next compliance is under regulation 33, which we have already spoken about. That is, for the financial year, the results will be declared within 60 days from the end of the financial year. That is, for the last quarter, we have been provided a time of 60 days for declaration of results. Next yearly compliance has been provided under regulation 40 of LODR. It speaks about a certificate from a PCS certifying that all certificates have been issued, that is, all share certificates have been issued within 30 days from the date of lodgement of transfer subdivision. That is, if any request has been received from any of the shareholders, then the company has executed that and issued the new share certificate within 30 days only. So a certificate with effect to this has to be issued by a practicing company secretary within 30 days from the end of the financial year, that is 30th April is the last date. Now, some of the compliances are for specified companies, that is top 100, 500, 1000, 2000. Let's speak about that also. So, two compliances are there which has to be done only for top 100 companies. First is the top 100 companies have to hold their AGM within 5 months from the end of the financial year. If we recall Companies Act, there we have been provided the time up to 30th September. 30th September is the last day to hold the AGMs. But here LODR has provided that for the top 100 companies, the AGM has to be held within 5 months from the end of the financial year. That is, on or before 31st August, they need to hold their AGMs. Second compliance for the top 100 companies is they have to provide a one-way live webcast of their annual general meeting. So annual general meeting, as and when it is being held, they have to do a live webcast of their general meeting. Now, our second category comes top 1000 companies. Some compliances are specifically for top 1000 companies. So first one is the top 1000 companies have to have at least one independent women director. Second is top 1000 companies have to constitute a risk management committee. Third, all the top 1000 companies have to take a directors and officers insurance for all their independent directors. Fourth is all the companies covered in the top 1000 category are supposed to issue a business responsibility report, which has been renamed as Business Responsibility and Sustainability Report. Next is top 1000 companies have to formulate a dividend distribution policy, which shall be disclosed on its website too, and also a link has to be provided in its annual report. Certain compliances have to be done by the top 2000 companies. First is top 2000 companies have to have a minimum number of 6 directors on their board. The quorum for the board meetings of such companies have to be 1/3 of total strength or 3 directors, whichever is higher, including at least 1 independent director. So that's all. In total, we discussed about the quarterly compliances, half-yearly compliances and yearly compliances, also the compliances which are specifically designed for the top 100, 1000 and 2000 companies. I hope this video will be very helpful for you all. Please do share it with your friends and please wait for the next video of this series. Thank you so much. Keep watching and be connected.